of our Zoom conferences, I'm going to ask that only the attorneys arguing the case that we're currently arguing have their video and microphone on. In other words, the first case to be argued today will be State versus State ex rel Lanter versus the City of Cincinnati. And so only those counsel should have their microphones and their video on. For everyone else, please make sure that you're muted and that your video is off until we call your case. The three cases on the docket today are, as I mentioned, Lanter versus City of Cincinnati, Bomba Du Bois versus Mcleod, and State versus Pitts. And we'll begin with State ex rel Lanter versus the City of Cincinnati. Ms. Martin, if you can begin by introducing yourself. Oh, there you are. I'm sorry. It is, as you can see, if you're in gallery view like I am, we have a lot of different boxes. So Ms. Martin, if you'll introduce yourself and indicate whether you're ready to proceed.
Yes, Jacqueline Martin on behalf of the City of Cincinnati. I am ready to proceed.
All right. And Ms. Rutowski?
Yes, Kim Rutowski on behalf of Sergeant Lanter, and we are ready to proceed.
All right, Ms. Martin, you have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
Yes, I'd like to reserve 3 minutes, please.
All right, and I will keep your time and let you know when you're at your time.
Thank you.
Whenever you're ready, you may proceed.
I plan to focus on the city's assignments of error and time permitting, then move on to the writ of mandamus issue, but please interrupt me if you'd like to hear about the writ of mandamus sooner. May it please the court, there is no right to an appeal from an advisory agency like the Citizens Complaint Authority, the CCA. This case should have been dismissed for lack of subject matter jurisdiction for 2 reasons. First, the legislature limited the appellate jurisdiction for the Court of Common Pleas with Revised Code 2506 to appeals from final orders that affect one's rights. Second, the Ohio Supreme Court further limited the jurisdiction of the Court of Common Pleas to administrative decisions resulting from quasi-judicial proceedings. The trial court did not have jurisdiction here because there is no final order that affected Sergeant Lanter's rights or duties, and the CCA does not hold quasi-judicial proceedings.
Let me ask you a question. Let's assume the facts are more egregious than the ones at issue here, and the CCA's finding was that he was a member of the KKK rather than he just uttered a phrase. And as a result of that, he finds out he can't coach Little League, his landlord evicts him, this parade of horribles ensues. And I guess at what level, if any, can he get redress against the CCA for such a finding, assuming he's ultimately exonerated by the police department?
Well, if something tangible did result and Sergeant Lanter was negatively harmed. So right now, he wasn't, because the chief of police did not accept the recommendation of the CCA. But if he had, and he had been disciplined, then he could have appealed that discipline through his collective bargaining agreement.
I understand that. My hypothetical, though, is assume that he does not get discipline in his employment, but he has collateral consequences in his personal life as a result of this finding that he says, are a stain on his reputation. Does he have any ability to seek redress against the CCA?
Perhaps he would have some sort of remedy in tort if he felt he'd been slandered, but no, the expansion of the appellate jurisdiction for administrative advisory recommendations should not be expanded. Just like if someone was found guilty of a human resources decision. Maybe they'd been accused of something in their workplace, but they weren't disciplined for it, but there was an investigation that was a stain on their employment record and they wished it wasn't there. They can't go in and appeal that to the Court of Common Pleas. There has to be a final order that affects a person's rights or duties, and it has to result from a quasi-judicial like proceeding.
So can you talk about, I'm trying to understand the hearing process. I understand that the CCA does not have to hold a hearing. In this case, it chose to do so. And so I guess and you know, there was notice given um, to everybody involved. I guess you can call witnesses potentially. Can you explain the hearing procedure and why the CCA would call a hearing?
So in fact, the CCA did not call a hearing, and I apologize that it is confusing. I only learned from a subsequent CCA related case that according to the CCA, they've never called a hearing. Each investigation results in a report and recommendation, and the director of the CCA has the ability to put that in front of the CCA board for either summary disposition or a hearing, and they have in their history never had a hearing. So this was actually for summary disposition, and the board's job is to approve or disapprove the report and recommendation. So what Sergeant Lanter was provided was notice that the case would be heard that day for summary disposition, and he was able to present public comment, much like a comment period during a city council meeting.
Let me follow up on Judge Bergeron's question, if I could. There is a difference between a private employment record that is not made public and the records from the city of Cincinnati, which are public records and so therefore available generally. Does that distinction make any difference when we talk about the collateral consequences?
Well, yes. When one signs up to be a public official, they are subject to public records laws. So by just the essence of being a police officer, people will make complaints about you, and that will be part of your employment record, which is a public record. So when people make complaints to the CCA, that's going to be a public record, and it's going to go into a report that is available. And police officers or citizens should not be able to go into the Court of Common Pleas and say that those public records should be sealed and redacted or hidden from the public, which is exactly what Sergeant Lanter achieved through this case.
But I have a question on that though, because so in this case, it's not just the complaint that's public record, it's the CCA finding that is public record. And you know, this can be detrimental to your reputation. I mean, basically he's being called a racist. He gets exonerated through the internal investigation, but the CCA finding is still going to be published. So does the CCA also publish the results of the internal investigation and say, okay, you know, we substantiated this, but there was another investigation that did not?
Do they? I can't say with complete certainty whether they include that, but the IIU investigations are also public. And notably, they are not subject to a revised code 2506 appeal or a writ of mandamus change. There's no appeal from the internal investigations unit, and the CCA is basically the citizens analog to the IIU. Sergeant Lanter could also, to defend himself, point out on his own the IIU exoneration, if we want to call it that, and the fact that he was not disciplined. So he's shown that he can do that if his remote and speculative harm ever comes to be.
Let me go back to a question about the procedures here. There is a section in the ordinance about what happens in a hearing. Is there anything in there about summary disposition other than the fact that it can occur? Like, here's how we structure a summary disposition proceeding or something like that? Because I didn't see that.
Not to my knowledge, aside from just saying that the board's job is to approve or disapprove of the report and recommendation. So jurisdictional limits on administrative appeals are both logical and necessary, because if every decision by each municipality's various advisory bodies were directly appealable, the court's docket could quickly become flooded. The CCA, for example, takes in hundreds of allegations of misdeeds by police officers each year. Should Sergeant Lanter prevail in this case, each discrete allegation could be appealed to the Court of Common Pleas by either officers or complainants. The record clearly establishes that Sergeant Lanter's rights were not affected by the CCA's recommendation. The Chief of Police, the final decision maker, rejected the CCA's recommendation and withheld discipline, adopting instead the internal investigation report issued by the Cincinnati Police Department. Because the CCA has no authority to reprimand, suspend, or otherwise discipline Sergeant Lanter, his administrative appeal should have been dismissed by the trial court. Courts have found that non-binding administrative findings, like the CCA's, are not appealable. In the Farron case, the 8th District held that a man accused of sexually abusing a child could not appeal an agency finding under 2506. He made similar arguments about the potential harm to his reputation for being accused of sexually abusing a child. But the court found that he showed no concrete harm to his reputational or pecuniary interest. And appellee points out that CPS records are kept confidential, but that was only one reason why the Farron appellant was unable to state a claim. The 9th District likewise held that the Summit County Common Pleas Court did not have jurisdiction over a citizen's appeal of a regional planning organization's recommendation to implement an environmental protection rule. In Helms, the 9th District held that because the regional planning organization only issues recommendations that must be accepted or rejected by the Ohio EPA, its decisions are not final orders. In this case,
Let me ask you this question too. Is there any mechanism akin to an expungement? So could he come in and say, hey, I was exonerated by the police department. I would like you to expunge the investigatory finding to the contrary. Is there any mechanism like that?
well, I don't think that mechanism exists, but I do think that over time he would fall off of the CCA's reports. They keep an ongoing how many times was this officer complained about? So if he doesn't get complained about, then he's no longer going to be brought up after a certain period of time. But again, there is no harm to this public record existing, that a independent citizen board felt that he had done something, and that's out there, but he can exonerate himself by saying, I wasn't disciplined, just like he didn't get disciplined. It's not a true harm under the law. It's not a justiciable harm.
And if he did get disciplined by the police department, he would have whatever remedies are available to him under the collective bargaining agreement. Is that right?
Yes, Your Honor.
And follow up to those questions. In Judge Bergeron's initial example, he gave an example where there was maybe an egregious finding by the board. And you suggested maybe there would be a tort cause of action if there was something very harmful. I mean, is that really a remedy? Could somebody sue the city for slander or false light privacy or something? I mean, I guess I'm going back to, is there a remedy in this case if there is bad faith or an egregious miscarriage, which isn't what we're talking about here, but in the future?
Well, it's actually a very timely question. There's a sort of high profile case going on right now where police officers have sued people who complained about them on the internet. So I wouldn't say that they have a claim against the city, but possibly against the complainant. And I'm not saying that I condone that or think that's the right way to go, but it's possible that he could have a claim sounding in tort against the complainant.
Thank you. And you have 1 minute left if you'd like to reserve 3.
Okay. As to whether the board holds quasi-judicial hearings, in a board meeting like Sergeant Lanter's, there is no oath administered, no rules of evidence, no cross-examination, no court reporter, no introduction of evidence, and it's explicitly not an adversary proceeding per the administrative rules. The only decision made by the board is whether to sustain the findings of the CCA's independent investigative report.
And just to follow up on that, as I read the procedures in the ordinance, you're saying there is no right to cross-examine witnesses. So even if there is a hearing, counsel, Lanter's counsel does not have a right to prosecute witnesses.
Yes, absolutely. And appellee tries to shoehorn a quasi-judicial proceeding into something that is just not. He is given notice that someone made a complaint about him and that will be heard, but that does not, as any lawyer knows, make something a quasi-judicial proceeding. So for
You
these,
are at your time, Ms. Martin.
thank you.
Ms. Rutowski, you've got 15 minutes.
Good morning. May it please the court. This case is not about what the complainant's complaint. It is about how CCA handled the investigation and the fact that they mischaracterized the only independent witness and basically put blatantly false information into their report and recommendation. Ms. Martin characterizes the notice that was offered to Sergeant Lanter as a summary disposition, and I would refer you to the record, page 33. The notice that he received states, as the respondent officer, you and the complainant are being provided with a copy of the investigation report and may challenge the findings and recommendations to the board. That is also.
But you never. There was never a hearing here, though, was there?
We would call it a hearing. And if you look at the transcript of proceedings from that hearing on page 65.
I have, and counsel only had, what was it, 6 minutes to provide comment. I mean, there was no calling of witnesses. There was no cross-examination. You basically had a public comment period, and I guess that would sound like a strange hearing to me.
That is, they call it public comment. However, when you look at Zach Southwood, who is the assistant city solicitor who sat in on the hearing, he describes it as, after conducting this hearing, those are the two options before the board. That's on page 65. So even the city solicitor who is there and assigned to give the board guidance on the law and their legal options called it a hearing. The Cincinnati Municipal Code calls it a hearing under section 3B. It's specifically described as a board hearing.
Besides
At that hearing, we did.
Judge Krause, go ahead.
Besides the fact that it's called a hearing, I think that we're more interested in knowing what happens at this hearing. So are witnesses, I mean, could Sergeant Lanter have called witnesses on his own behalf to speak? To testify?
We could have brought additional people in to testify or to provide comment as they're describing. We believe it's quasi-judicial because we were able to go in and make the arguments. We provided additional evidence. And at the core of this case is the fact that we were urging the board to simply listen to their own CCA interview. We weren't asking them to reinvestigate. We wanted them to actually listen to the interview. And they refused to do that.
Well, I guess going back
we believe the fact that
going back to the questions we've been asking in 3D, which details what happens at an actual hearing, I just don't see a right for anyone to call witnesses, to cross-examine witnesses, to introduce new evidence. Under 3D, it seems like the purpose is only to ensure the completeness of the investigation, and that it's specifically not an adversarial proceeding. So I'm just trying to square that with when we talk about hearing in the context of quasi-judicial, it has the normal trappings of due process. And I guess I'm just not seeing those in section 3B.
Well, we have the notice, the opportunity to introduce evidence. We were able to present the evidence to the board. They also have court-like powers and the ability to subpoena witnesses and subpoena documents. That's provided in the Cincinnati Municipal Code as well. So they have all the powers of a hearing. And in this case, we did provide the evidence and we did receive notice. And that actually conflicts with the CMC if we were to look and say he doesn't have the opportunity for a hearing when it specifically grants him the ability to challenge and appeal to the board. So we took advantage of that. So we believe under the quasi-judicial that we did have a hearing. But in the event, as far as our cross appeal, in the event that the court determines that this is not quasi-judicial,
Before you move on, can you, I'm trying to understand how this is a final order as well. Because it was just a recommendation. And so under 250601, how is this a final order?
The final order is the report that goes on to CCA's public website. This is a website that is freely accessible to anyone. I know counsel referred to the Farron case, and that was actually a confidential report, and it would only report it to law enforcement. So the public didn't have access to this. So the fact that this immediately goes on their website, and to argue that it is not a harm to a police officer in this day and age to have a finding that you're a racist, that you're guilty of racial discrimination, and have that officer have absolutely no ability to correct the inaccurate information. It's not.
But I guess this is where I'm struggling with this point, which is in your brief, you say that the harm to him has to do with his future career prospects, but the police office has investigated and has exonerated him. So I guess tying back to Judge Krause's question, like, where is the harm to him that's something beyond just speculation?
Well, unfortunately, the harm is in the event, if he gets involved in a critical incident and he is sued. And we all know plaintiff's lawyers, the first thing they do is request public records. And this would be a public record, a finding of racial discrimination from CCA.
But yeah, let's use that for a second. So let's say he does get sued, and some plaintiff's lawyer finds this report and says, aha, this shows you're a bad person. Couldn't he then just show the countervailing report from the police department and say, no, that's totally bogus? I mean,
absolutely, he can do that, but that would be after everything would be drugged through the media, and Sergeant Lanter's reputation would be completely obliterated in this day and age with a sustained finding of racial discrimination that was based on inaccurate information. That's what the court, and the key to this case is the city argues that this would open the floodgates for police officers to come in and challenge CCA reports and recommendations. But CCA was created in 2002 as part of the collaborative agreement. This is the first time that we have challenged the FOP on behalf of Sergeant Lanter has gotten involved in a case and actually challenged a CCA report.
I need to go back.
That it was.
Sorry to interrupt you, but I want to go, and I understand your issue on his reputation, especially in this day and age, and that is, it's certainly concerning to have that out there in the public. But when I look at 250601 to determine a final order, it has to determine rights, duties, privileges, benefits, or legal relationships. And so how does damage to his reputation fall into any of those categories?
Under the Cincinnati Municipal Code, the CCA has the duty to provide fair and impartial reports and investigations. So Sergeant Lanter has a right to a fair investigation. And in this case, the investigation was far from fair. So they have a duty to to produce a fair investigation, conduct a fair investigation, and he has a right to a fair investigation, and that's in the Cincinnati Municipal Code under the CCA.
But you have to have a judge, you need a judge to make a determination of whether it's fair, right? So I guess I'm just looking at the fact that I feel like this statute is, it's precluding the subject matter jurisdiction of the court, because, I mean, if you're just saying that he has a right to a fair investigation, that is determined later after it's appealed.
Can I ask you a follow-up question before you answer that? Is it your position that immediately upon the determination by the Citizens Complaint Authority, that at that point, a detrimental order would be appealable to the Court of Common Pleas before the police investigated and made a decision? And even if the police investigated and made a decision and upheld it, is your position that it's appealable to the Court of Common Pleas no matter what?
It's separate. The police investigation is completely separate from CCA. Once the CCA report is finalized and approved, and the chief does not do that. The chief gets a copy of it. The city manager is the one that signs off on it. Once it's final and approved, then we have the ability to file an appeal with court.
Even before any determination is made by the Cincinnati police?
Correct. That's the Cincinnati Police Department they have the ability to run a parallel investigation, and in most cases they do conduct an investigation. And if Sergeant Lancher had been disciplined, then yes, we would have taken that through the collective bargaining, the arbitration, and the grievance process. In this case, the facts were so egregious, they urged, in fact, the chief urged the city manager not to approve this report. So as soon as the CCA report is approved, regardless of the police department's investigation, it's this report that's the issue, because this report, it goes on to CCA's website. Internal investigations are not posted on a website. The only way you would get that information is to do a public record request, where in CCA, it's immediately public record on a website. So unless you know of an investigation.
Could I ask just one follow-up question? Ms. Martin made a reference to, if we accepted your theory, then both police officers and complainants could appeal. And I guess my question to you is do you agree with that?
Under the Cincinnati Municipal Code, it gives both the officer and the complainant the ability to challenge and appeal the executive director's recommendation to the board. So yes, a complainant would have the ability to file an appeal.
Okay, thank you.
And if I may, under the writ of mandamus, in the event that this court does find that this is not an administrative appeal, we believe that we have successfully pled all of the elements for a writ of mandamus. As has been stated, Sergeant Lancher has a right to a fair investigation. He has a right to have accurate information posted under the Cincinnati Municipal Code.
Specifically, what is the remedy that you want to achieve through a writ of mandamus?
In this case, we have Misty Vandenhatter, the independent witness. If you read his...
Oh, I think you're frozen. Judges Krause and Bergeron, can you hear her?
No.
We have lost you there. What I'm going to do is, I think right, I think she's frozen. If you can still hear us, I'm going to ask you to log
that
off.
CCA put into their investigation.
Ms. Rakowski, can you hear us? If you're speaking, we cannot hear you. I think we have lost her. She now, video looks frozen. Ms. Rakowski, I'm going to ask that you log off and log back on, and you will have a minute left.
Okay.
Oh, wait, now
Okay.
we hear you now. You have 1 minute left, and then we'll switch over to Ms. Martin.
Her internet's not working.
No, all right. Counsel, if you will log off and try and log back on, we'll wait for you.
No idea if she hears you.
I will send a chat to her. Oh, I think she just logged off. Mr. Souter, if you do not have her requesting to come back in, if you could call her and have her just call the phone number, that might be a solution.
Yeah, okay, I'll try to get in touch with her. She just logged in on her iPhone.
Great, thank you.
I think I do.
We can hear you now, Ms. Rutowski.
Excellent. I believe it's our internet that was having a problem, so I reverted to cell phone.
That's great. You have 1 minute left, and then hopefully you can hear Ms. Martin when it's her turn. But you do have 1 minute left.
Thank you, Your Honor. I hear you crystal clear. So on the mandamus, in the event that there is no remedy under 2506, there would be no adequate remedy at law. Plaintiff's legal right under the CCA, Cincinnati Municipal Code, he has a right to a fair and efficient investigation. It is essential that the CCA uniformly be perceived as fair and impartial and not a vehicle for any individuals or groups to promote their own agendas. That is the CCA's core principle. So Sergeant Lanter has a legal right to the fair and efficient, unbiased investigation. Similarly, the defendants have the legal duty under the Cincinnati Municipal Code, specifically the director under Cincinnati Municipal Code Section 1, Article 28, complaints be resolved in a fair and efficient manner. The executive director will be accountable for the efficient operation of the CCA and for the achievement of the desired outcomes set forth above. That is supplemental record page 188, section 2B of the Cincinnati Municipal Code. Likewise, the city manager has a legal duty under Section 4 of the Cincinnati Municipal Code, Article 4, Section 3. The duty of the city manager is to see that all the ordinances of the city and the laws of the state are enforced. So he would be tasked with, and it's his legal duty to enforce the Cincinnati Municipal Code and the CCA section, Article 28 of that code.
And Counsel, you are at your time now.
Thank you, Your Honor.
Is there any question for counsel from the panel?
No.
All right. Ms. Martin, you have 3 minutes.
Thank you. The 3 elements to establish a writ of mandamus are that the plaintiff has a clear legal right to the relief prayed for, that the defendants have a clear legal duty to perform the acts, and that the plaintiff has no plain and adequate remedy in the ordinary course of law. Even if the writ of mandamus was not dismissed because Sergeant Lanter prevailed on his 2506 claim, Sergeant Lanter fails to meet any of the 3 elements for a writ of mandamus. Sergeant Lanter claims that he was denied his right to a fair and impartial investigation and a fair hearing. In support of this, he repeatedly claimed that the CCA's investigation contained false evidence. But all of the allegedly false information relates to the testimony of witness Vandy Hattert. The decision as to whether eyewitness testimony is credible or reliable is entirely subjective. Sergeant Lanter argues that the CCA has a legal duty to place its investigation interview or the investigation summary with the IIUs, but the CCA is prohibited from considering the IIU's testimony according to its charter documents. It was created to be independent from the IIU. The Sergeant Lanter may sincerely believe that witness Vandy Hattert's statements from the 2nd and 3rd interviews conducted by the IIU were more credible, but that does not make that CCA interview categorically false. Reasonable minds can differ when weighing eyewitness testimony, and eyewitness testimony can change over time. The CCA properly exercised its discretion in only considering the initial CCA interview. For these reasons, there's no clear legal right for Sergeant Lanter to alter or delete the public records of the CCA. Next, a mandamus action is only appropriate under circumstances in which there is a statutory duty of a public official to carry out a task, such as seeking a determination on an application for a license, compliance with public records laws, or whether or not to open court records. On the other hand, if there's no codified legal duty on a person or entity, an extraordinary remedy like a writ of mandamus is inappropriate. The broad duty to fairness and impartiality asserted by Sergeant Lanter could open the floodgates to writ of mandamus claims. For example, human resources investigation should be fair and impartial, but that does not mean that there is a grounds for a writ of mandamus for every employee who is certain that the allegations against him are false, even if he received no discipline. Instead, any discipline actually imposed would be appealed. And because Sergeant Lanter works for a public entity subject to public records law, it would be contrary to the public interest for investigative records to be altered or for an advisory community board's non-binding recommendations to be overturned by a court. As to the 3rd element, officers have an adequate remedy at law if they are disciplined as a result of a CCA recommendation. They can appeal that through their collective bargaining agreement.
Well, but I think his issue is he wasn't disciplined, and he wants to seek some relief, and he's not able to obtain it.
Oh, no, I think she's frozen too. Mr. Souter, I'm going to ask you a quick question. Could some of the problem be at our end that we have too many people on the Zoom at one time?
I don't think that's an issue, but it could be if you want to ask everybody else to log off for now.
Can they be put in the waiting room?
Yeah, sure. I can put everybody else in the waiting room.
Let's try that.
Okay.
Ms. Martin, if you can hear us, wait just a moment. Oh, I think she logged off.
Yeah, everybody else is in the waiting room.
All right, I think she logged off, so let's wait for her to log back on.
It might be better to keep people in the waiting room until they argue.
Yes, Mr. Satter, what we can do is just alert everybody when we can bring everybody in at the beginning so that they know that we're here and going, and then put them in the waiting room. I'm not
Sounds good.
sure that has anything to do with our problems today, but in case it does.
In an abundance of caution.
Yes, thank you.
You're welcome.
I think it's more likely that it's on the other end, but
When it happened to me, it was on my end. It was my internet.
It is much clearer on my cell phone, that is for sure.
Hi, I'm so sorry, Judge Bergeron. Could you please repeat your question?
Sure. My question was on the clear, on the right for, I'm missing the term, the clear legal right. You said that, well, if he gets disciplined, then he's got that avenue. But my question was, well, in this case, he didn't get disciplined and he still wants some relief. And if you're right, then he doesn't have a clear legal entitlement to relief otherwise.
That is correct. He does not have a clear legal right to overturn this advisory community body's recommendation to his boss that he be disciplined. So for these reasons, oh, sorry.
I was going to say you have about 30 more seconds left.
For these reasons, the city requests that the decisions of the trial court be overturned. Thank you.
All right, thank you. Thank you both for your arguments this morning, and thank you for your patience. We do run into glitches once in a while, but they can always be overcome, I found. So thank you, and we will take the matter under submission and give you a timely written opinion. And Mr. Souter, then, if you could let the attorneys in for our next case.
Thank you.
Ms. Horn, Mr. Recker, if you could both start your videos and unmute yourselves. Great, we can see you. Can you hear us?
Yes.
All right, the next case on our docket this morning is Bomba Du Bois versus Mcleod. Counsel, if you will introduce yourself for the record, please.
Good morning, Your Honor. My name is Stephanie Horn. I am here for Ms. Bomba Du Bois, and I'm ready to proceed.
Thank you. Mr. Recker?
Yes, thank you, Your Honor. My name is Andy Recker. I represent the appellee in this case, also who is the employer, Sodexo Marriott Services.
All right. Ms. Horn, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Yes, thank you, Your Honor. If I could reserve 3 minutes for rebuttal, I'd appreciate that.
All right, and we're ready whenever you are.
All right. Thank you very much, and good morning. Good morning, Mr. Recker. As you know, this is a workers' compensation case. Ms. Du Bois is here asking for reversal of the trial court decision which denied her the right to participate in the workers' compensation fund for the condition of depression NOS, or not otherwise specified. The trial court denied her that right despite having only the testimony of Ms. Du Bois and 2 experts. Both of the experts agreed via testimony that she has the condition of depression NOS and that it is at least one of the causes of her depression. One of the causes of her depression is the work injury. One expert who evaluated on behalf of Ms. Du Bois, Dr. Lester, indicated the depression was directly caused by the work injury. The defendant's expert, Dr. Murphy, acknowledging the work injury was at least a contributing factor to her depression. And that, of course, goes to the crux of our first assignment of error. We believe the trial court findings are against the manifest weight of the evidence, and the court's conclusions are not supported by the evidence of record.
Well, let me ask you about that, because it seems like you framed the first assignment of error as a legal issue, but I was wondering if it is more a manifest weight argument.
Yes, Your Honor, I do think it is a manifest weight of the evidence argument. In this situation, we have, again, the two medical experts. You do require medical or expert witness testimony in this type of matter. And we believe that the testimony of both of the experts are supportive of the depression being present, of course, and I don't think that's disputed at all. But also that it is at least caused, the work injury was at least a contributing cause of the depression. One note I would make with regard to the historical facts of the case, Ms. Du Bois did have a severe knee injury. There is some incorrect information in the findings of fact in the trial court decision on page 2, paragraph B. He notes prior surgery of January 2019 and October 2019. Rather, Ms. Du Bois had this injury in 2007. She had a total knee replacement in 2009, multiple manipulations under anesthesia, and a revision of the total knee replacement in 2016. So all of this took place consistently over the course of several years, all arising out of and connected to the original work injury, all of these procedures that she had and the difficulties that she had as a result of that injury. She had physical therapy and other treatments were all unsuccessful in returning her to her prior level of function. She testified as to severe pain, having been on and off work, using a cane to get around, and she was never released to work following that final knee revision. Of course, in order to have a psychological condition allowed in the claim, she has to prove that the condition is present, that she suffers from it, and secondly, that the psychological condition arises out of the physical injury she sustained. And in this instance, again, the court found she did have the depression, no contrary evidence to that. Both Dr. Lester and Dr. Murphy both say it's appropriate and testified to that. So it's not really, that we're arguing that dual causation should have been applied by the trial court. It's our position that the court, if the court had properly applied the dual causation doctrine in its legal analysis, that Ms. Du Bois would have been granted the right to participate for this depression.
Well, let me ask you about Dr. Murphy's testimony, because he does testify at one point that he acknowledges it's a contributing factor to the workplace injury is a contributing factor to the depression. But at other points in his testimony, he says she would have been depressed regardless. So the way I read that is there's an inconsistency in his testimony. And why wouldn't we just let the trial court sort that out in due course?
Well, two things, Your Honor. First, I think that does go to the second assignment of error that we posited, that the testimony is so inconsistent as to be unreliable. But with regard to the first assignment of error, I think Dr. Murphy did testify on direct examination that the work injury wouldn't have had anything to do with the depression. If you go on and review his testimony, he never really provides any adequate explanation for why that is. In fact, he testified at different times upon cross-examination, in fact, that there was no record of any prior treatment of depression, no report of depression or diagnosis of depression with regard to any of these other life stressors or life events that he would, on direct examination, have the court believe solely cause the depression, or that those she would have had the depression regardless of the work injury, and that's direct contrast. And I think somewhat, looking at the court's failure to actually, in its findings of fact, give a full view of all that was connected to this work injury. It's difficult to see how these life stressors could cause the depression, and we're just going to ignore the work injury that resulted in multiple surgical procedures over the course of many years, and certainly.
Well, I mean, it's not difficult to see. It's not difficult to see how the life stressors could cause the depression. I think the thing that I was trying to figure out is there any actual evidence, clinical or otherwise, that those life stressors did cause the depression? I mean, everyone can have bad stuff happen to them, but people, react to that different ways.
Yeah, and Your Honor, I think the answer to that is no. And I think at one point in my brief, I talked about Dr. Murphy's testimony, and in his deposition transcript outlined on page 4 of the brief, he does testify that the work injury in 2007 and its effects, including obviously the treatment she's had, ongoing limitation, disability, and what that led to, are one of the contributing causes to her having a depressive disorder. Dr. Murphy responds, it's one of many factors. But is it one of the factors that has contributed to or caused her to have this depressive disorder as you've diagnosed it? Correct. And he answers correct. And that he holds that opinion to a reasonable degree of psychological probability. So this is in conjunction with some of these other stressors. And he's saying, yes, she has the depression. If she didn't have the injury, she would have depression, but it is also a factor through it. But Dr. Murphy then, as I mentioned earlier, I think also went on to testify there's no evidence of a diagnosis of depression, treatment for depression, mention of depression related to any of those other stressors he identified. Page 7 of our brief, the transcript, page 22 at number 75. He notes that there is evidence in the record that throughout this time her knee was painful. He doesn't indicate that, but we indicate that in the record there is evidence to demonstrate that her knee was painful and giving out on her at work. In 2015, that's a stipulated exhibit 4.4 that discusses that. She has to use a cane and she was finding it difficult to work.
Dr. Murphy examined her, correct?
Yes, he did do an evaluation.
And so did he ever say, something to the effect of, she says it's all based on this workplace injury and not being able to go back to work. But in my clinical assessment, I've concluded that what she's really saying traces its roots to some other cause. Like, did he say something like that?
I don't think Dr. Murphy did say that in his testimony. I think Dr. Murphy did at different times say somewhat different things. And again, that kind of goes to assignment 2 and the equivocal nature of his testimony. So upon direct examination, he did, he did support that the injury would not, she would have had depression anyway. The injury really didn't have anything to do with it. But later on, he testified again that the work injury was a contributing factor and that there was no evidence that there was any depression noted in any of the prior medical records that he reviewed or in her testimony. In fact, he indicated, she testified that that the depression did come during the course of this work injury.
Now the court specifically found that her depression arose as a result of her not being able to work, right? That was the court's finding. Or did the court make any findings that her depression came from for other reasons?
I think that the court indicated in its opinion that the dual causation doctrine would apply, and then the court did discuss some exceptions for psychiatric conditions and so on. He does talk about Ms. Du Bois' testimony at the time of trial that, she did discuss some issues related to not being able to work and how that was difficult for her, and she did have depression. Obviously, depression is not something that happens on any particular day. It occurs over time. It's always a flow through as a result of events rather than anything that would happen on a specific date. But I think what's important to note and what's relevant to note is we are looking at something that requires an expert witness testimony, and neither Dr. Lester nor Dr. Murphy provided testimony that it was specifically her inability to work that caused her to develop depression. Dr. Murphy, to the extent that he said she would have had depression anyway, was looking at factors such as her obesity. He discussed hypoglycemia. He discussed diabetes, which, as we noted in our brief, the claimant testified she did not even have diabetes. But Dr. Murphy at one occasion testified that all those conditions would be in the mix. She also had other life events, as all of us would, with regard to deaths of family members and so on throughout this period of time. But also during the period of time, she remained active. She remained in the workplace, and there's no indication via Dr. Murphy's testimony or anyone else that those life stressors or those other factors caused any significant interruption in her mental well-being. It's not until she had this work injury, and Dr. Lester, of course, provides his direct examination that it was the work injury that really culminated in the depression.
And Ms. Horn, you have about 30 seconds left if you'd like to reserve 3 minutes.
Thank you. Yes, again, I mean, we do have the testimony of Dr. Murphy on multiple occasions. He said she would probably have the problems with depression in the absence of the work injury. However, he also testified multiple times her work injury may be a factor. It's in the mix. That's perhaps one factor, and those are all cited in the brief. So at least on 5 occasions, Dr. Murphy at a bare minimum indicated the work injury was one of the factors that does meet the definition. It is a contributing factor to the injury, and thus why we indicated that we believe it is a proximate cause of the injury at a minimum of the diagnosis in concert with the work injury. And so for that reason, we believe both medical experts testified that the work injury is a contributing cause of the depression, and she should be permitted to participate in the workers' compensation system for that condition.
All right, thank you. Mr. Recker, you have 15 minutes.
Yes, thank you, Your Honors. May it please the court, I would like to begin by addressing the first assignment of error, the dual causation, which by all accounts appears to be based on solely testimony of Dr. Murphy. Very briefly, I want to touch on a couple of the cases that were cited in support of this dual causation theory, as well as.
Well, I guess maybe the threshold question is: do you agree that dual causation is the appropriate analysis here?
Absolutely not. And the reason that I say that is not only based on the case law that I will argue to you is simply not applicable to dual causation in this type of case, but also the testimony of Dr. Murphy himself. The first thing, and feel free to obviously interrupt anytime if you have any questions about my analysis of these cases, but there are 2 cases that are discussed in both.
So in other words, you think the trial court was wrong to go down the dual causation path?
The trial court did not actually go down the dual causation path, as you will see. The trial court, Ms. Horn, or appellant, talked about how the court said that they would use dual causation. However, what the trial court indicated was that dual causation would be discussed in its analysis. The trial court also discussed remote causation and proximate causation. Ultimately, the court made the determination based upon expert testimony, as well as the testimony of plaintiff herself at trial, which has notably not been discussed in the brief of appellant. So the trial court, Your Honor, did not actually use dual causation in its final decision, which I would argue was correct because dual causation does not apply. The cases that are discussed, this Murphy v. Carrollton Manufacturing, which is a Supreme Court case from Ohio, and then the Norris v. Babcock and Wilcox case, which is a 9th District case. Both of these cases involve an injured worker who has 2 causes, 2 proximate causes that contribute to cause the ultimate injury or result. In the Murphy case, a injured worker had a back injury and eventually had a pulmonary embolism and died. And the experts differed on, the real question was whether the jury was entitled to an instruction on dual causation. And the dual causes were the back injury and then the eventual pulmonary embolism that happened after years and years of bed rest because of some multiple failed surgeries. And the court in that case said that the jury was entitled to a dual causation instruction. And the court was very clear in stating that when 2 causes, 2 proximate causes join together, they're both the proximate cause. And that's the dual causation doctrine. Similarly, the Norris case, the Norris v. Babcock case, this is a case where a lifelong smoker.
Let's go back to the facts of this case.
Sure.
So what is, I mean, your guy testified that the injury is one of the factors that contributed to the depressive order. I mean, you agree with that, right?
Yeah, absolutely.
Okay. So what is the cause other than that resulted in her depression?
Sure. So Dr. Murphy testified on direct examination and cross-examination that the cause of the plaintiff's depression was the other life stressors that he discusses in great detail in his report. These included the death of a son, the death of her father, whom she was very close with, a divorce, other medical conditions. And then on cross-examination, he concedes that, yes, the work injury may have played a part, but then he's very clear, not only on cross-examination, but also on redirect, that she would have developed this condition in the complete absence of the injury, which—
Well, I guess one thing I'm struggling with is, like, in a normal workers' comp case where it's not a psychological injury, it really matters what the physician says in terms of kind of attributing, tracing from the injury to the workplace injury to the harm that's being suffered. But in here, when it's psychological, as I read his testimony that was offered at trial, it honestly just seems like he's speculating. He's like, a lot of bad stuff happened to her, and that would, you can see someone being depressed by that. And I agree with that in some respect. Like, yeah, a lot of bad stuff happened to her, and I could see that being a basis of depression. But clinically, like, don't you need some connection to what she said for that to actually constitute a cause? I'm sorry that was rambling. I don't know if it made sense.
Well, I think I understand your point, and feel free to stop me again if I'm getting off course. But yes, I understand exactly where you're coming from, and I would say two things. First of all, Dr. Murphy is a board-certified licensed psychologist that examined her in person about 10 years after the initial injury occurred, which is when this request for this additional psychological condition came into the mix. And he opined to a reasonable degree of psychological probability that she would have developed this condition in the absence of the 2007 injury itself. Now, further complicating things was the plaintiff's testimony at trial itself. It was very difficult if you read the trial transcript, and I'm sure you've been through all of these documents ad nauseum, but it was very difficult to pin her down on when her depression started. That I asked her many times at trial, and then in closing, the court asked her directly several times, this is towards the end of the trial transcript, when did you start feeling depressed? And she had a very difficult time articulating when that onset was.
Well, and it's depression. It's not like you wake up one day and you're like, I'm depressed now. Like, it's a gradual thing, right?
Fair. But what my point is that Dr. Murphy, it's conceivable that this clinician would have a difficult time nailing it down to a certain cause, but that doesn't eliminate the requirement, as you started touching on earlier, that there's a proximate causation between the eventual condition and the injury itself. And
But didn't he say there was?
no, he said that she would develop, he said it could have been a factor, but he said that she would have developed this condition in the complete absence of the injury itself, which I would argue under the Armstrong case removes causation completely, proximate causation. If she was,
but he said he conceded it was a contributing factor to her depression. And I guess following up on Judge Bergeron, it's not like a broken bone where you can say the fall off the ladder caused the broken bone. Now, maybe you had osteoporosis, so you might have broken the bone anyway at some point in time. But I mean, depression can be chemical. It can be, it's all those things. And if your expert says it was a factor, why isn't that proximate cause?
so
It doesn't have to be the sole proximate cause.
So great questions. First of all, you're exactly right. This is not a condition you can put an x-ray over. And I think I actually talked to the plaintiff's expert about that exact thing. And ultimately, Dr. Lester provided testimony that he felt in retrospect that he should have diagnosed her with a dysthymic disorder, which is a completely different condition. But to answer your question, I think Dr. Murphy was being quite reasonable in testifying that he's not examining her in a vacuum. He's not eliminating this. I think it would have been unrealistic to say that this 2007 injury and all of the surgeries may not have played some small role in the eventual development of this condition. But by testifying very clearly on multiple occasions that she has all of these multiple other significant stressors in her life that would have developed this condition in the absence of this injury and the subsequent surgeries, if it would have occurred regardless of whether she gets hurt in 2007 or not, then that removes proximate cause. And Your Honor, if I could direct you to one additional case that's very instructive. Of course, I didn't stop looking at case law after I briefed this, and I came across another case that I believe is directly on point. This is McRoberts v. General Electric. The site is 2013, Ohio, 3083. And the reason I cite this case is it really goes directly to what you're questioning right now. This is a case where an injured worker claimed that he had sustained carpal tunnel syndrome as a result of his work at General Electric. The employer's doctor felt that the work contributed to it, but that he would have developed it anyway. And he apportioned it even. It was Dr. Whitsitt, he provided an opinion that the work injury or the work duties were probably 30% responsible for the development of this condition. And in this case, the employer asked for a reversal of the trial court decision based on this dual causation theory. And the court ultimately held that the plaintiff in that case had failed to cite to any case in which a claimant seeking workers' compensation benefits has prevailed, where the opposing party's expert testified that 70% of the cause of the medical condition for which he is seeking benefits is attributable to factors other than his employment, nor are we aware of any. That's the court talking. And that's very similar to what's happening here. You have Dr. Murphy testifying, sure, there may have been this small percentage of involvement with this injury and the surgery and the eventual development of this condition, but it would have developed anyway. And you essentially have an argument that, well, let's say it was 5% related, then dual causation should apply. The cases on dual causation are two causes that combine to lead to this eventual result. That is not what happened here. You have expert testimony that she may have had this small interplay with this injury and the eventual development of this condition, but that's ignoring the fact that she has these multiple other significant life stressors, and more importantly, that this condition was going to develop in the complete absence of that injury and surgery.
Yeah, but again, with depression, I mean, we can't say, oh, I'm a little depressed because of these stressors, and now I'm more depressed because of this. You can't really parse it out the way you could with other things, can you? And once it's a cause, that's what I'm still struggling at. Once your expert says it is a cause, are you arguing it's a remote cause, which I think is what the court said?
I would argue, Your Honor, again, great questions. I would argue that, as Dr. Murphy testified, this may have been a small contributing factor. However, Dr. Murphy was very clear multiple times that if she didn't have the injury, that she would have had this depression anyway. So in that scenario, under the Armstrong case, Armstrong is very clear that the psychological condition that's being requested, because psychological conditions are a strange animal. You're exactly right. This is not a condition that you can say, that's the day I broke my arm, or that's the day I hurt my hip. These are conditions that are difficult to pin down. So the Armstrong case, the Supreme Court, in trying to kind of nail down how to look at these types of cases, delineated this and said they have to come from the allowed physical conditions in the claim, the conditions that are in the claim, not the other conditions that they might have, but the allowed physical conditions. So what I would argue, or what I would posit to you, is that the trial court was well within its abilities to evaluate the evidence, to determine what was most probative, including the plaintiff's testimony. And the trial court determined that not only he didn't ultimately use dual causation, which I feel was appropriate, but he ultimately determined that the cause of her depression did not appear to be the allowed need conditions in this claim. And I would argue that that decision was based on the medical evidence within the file, including the expert testimony, as well as the plaintiff's medical records, which were stipulated to. There's a giant packet of records contained within the record, as well.
Did the trial court find that her depression resulted from her inability to work?
That is what his ultimate decision was, correct.
But the inability to work came from the knee problem.
So that's a good question. They kind of refer to that as the sequela of the injury. And Armstrong, unfortunately, did not really dive into how close of a call that is, and no cases have really gotten into the meat of that since. So I agree with you, Your Honor. That's kind of getting closer to what potentially might be a little bit more complicated. Is that part of the allowed conditions, the sequela rather, or not? But addressing the assignments of error before you were dual causation and then the improper standard of review. And I would argue that the dual causation theory simply is inapplicable based on Ohio case law, as well as the testimony of the expert witnesses in this case. And again, the last thing I would say on that note is that the trial court, as finder of fact, weighed the evidence and determined that in the end that the plaintiff had not met her burden of proof of demonstrating that this condition was related to the 2007 injury or the allowed conditions in that, the allowed physical conditions in that claim.
And you have 1 minute left if you'd like to use it.
Thank you. Very briefly, I would just point out in closing a couple of things. I took some notes here, and of course, I haven't even touched on those at all. But I would just point out that the main assignment of error appears to be the trial judge's discussion in his findings, or in his order rather, that he was going to use this dual causation, or at least examine dual causation, but he ultimately did not come to a conclusion based on dual causation. I would argue that the trial judge has no requirement to end up making a decision based on a causation theory that he discussed. As I said, he discussed remote cause, proximate cause, and dual cause, and ultimately found that the plaintiff simply could not meet her burden of proof in this case. I would argue that there has not been a single case that I could find in the state of Ohio where this type of theory has been attempted to be applied to a psychological condition. And I think that's partially because it is a slippery slope. As you've all pointed out very, very clearly, this is not a condition you can put an x-ray on and say this is when it happened. You have an expert witness in this case, Dr. Murphy, who clearly testified that while it may have been a factor, as I said, I think that was reasonable. He's not looking at her condition in a vacuum. She would have developed this condition in the complete absence of that injury, which takes this out of dual causation completely.
And Mr. Recker, you are at your time.
Thank you, Your Honor.
Ms. Horn, you have 3 minutes.
Thank you, Your Honor. Yes, obviously, we think the court should have applied the doctrine of dual causation. We think the trial court did provide it. In discussing that, the court notes plaintiff argues the principle of dual causation applies. Obviously, the court will use the dual causation doctrine in its legal analysis. With regard to the application of psychological conditions arising out of the work injury, one of the cases that the court talked about was Phipps versus International Paper Company, and talking about dual causation. In that case, the claimant had a physical injury, but the employer's expert there noted they were attributing the depression to other factors as well. But in that case, the expert noted she was strongly disposed to depression based upon childhood and family history, dropping out of school, becoming pregnant at 16. And there were a number of other factors relative to it, died by suicide. And the judge in that case ultimately found that the claimant did have predisposition, to depression that had caused the depression. This situation is one in which Dr. Murphy may have made the gratuitous statement, and I would agree somewhat speculative statement, that she would have had depression in any event, but there's simply no evidence to base that statement on. And Dr. Murphy clearly did testify that based upon the work injury and its effects, including her treatment, ongoing limitations, disability, and what that led to are one of the contributing causes to her having a depressive disorder, NOS. It's one of many factors, he said. Okay, but it is one of the factors that has contributed to or caused her to have this depressive disorder, as you've diagnosed it, correct? And he answered yes. And he responded to that within a reasonable degree of psychological probability. So he did opine that this condition, that the work injury would have been a contributing factor. We would ask that you consider that as proximate cause. There can be more than one proximate cause. And in this situation, at a minimum, Dr. Murphy agreed that the work injury was one of the causes, one of the contributing factors to her depression. Dr. Lester obviously agreed that it was the direct result of the work injury. And based upon that evidence, the trial court's finding that she should not have the right to participate for this condition was against the manifest weight of the evidence. With regard to the assignment of error number 2, and I think that does kind of go to Dr. Murphy's somewhat equivocal testimony. It sort of depended on who was asking him the question in some ways, but very clearly he did support that this was a contributing factor to the depression. The work injury was. She had very serious treatment and very many difficulties following the work injury. Yes, she had life events. Yes, she had life stressors, as each and every one of us do. Yes, she had difficulty articulating to the trial court exactly the date on which her depression began. But we're relying on the medical testimony, the testimony of the experts. Neither one of these doctors testified that it was depression due to her inability to work, but both testified that her work injury was at a minimum a contributing factor to her depression. And for that reason, we would ask that the trial court's decision be reversed.
All right, thank you. You are at your time.
Thank
Counsel,
you.
thank you very much for your arguments today. We will take the matter under submission and give you a timely written opinion.
Thank you very
And
much.
Mr. Satter, I see that you are letting everybody in for the next case. And the next and final case to be argued today is State versus Pitts. Counsel, if you will please turn on your video and turn on your microphones. And if you will introduce yourself, let's start with you, Ms. Nelson.
Good morning, Your Honors. Sarah Nelson on behalf of Mr. Pitts. Ready to proceed?
Mr. Crowley, if you will introduce yourself, please.
Yes, ma'am. So good morning, Judge. Scott Crowley on behalf of the City of Cincinnati, and I'm ready to proceed.
All right, Ms. Nelson, would you like to reserve any of your 15 minutes this morning?
Yes, I'd like to reserve 3 minutes for rebuttal, please.
All right, and I will keep your time whenever you're ready.
May it please the court, and good morning, Mr. Crowley. Sarah Nelson again here on behalf of the appellant, Mr. Jerry Pitts. This case concerns the application of the affirmative defense of self-defense. And as this court is aware, Ohio's self-defense statute changed on March 28th, 2019 under House Bill 228, altering the burden of proof once the affirmative defense is asserted. Mr. Pitts's trial commenced on April 4th, 2019, a week after the effective date of the statute. And it's our position that the trial court erred in not applying the new law as it was in effect at the time of Mr. Pitts's trial. Applying the new self-defense law would not violate the rule against retroactivity. And I think this court can reach that decision in one of two ways. First, primarily being reliance on the 12th District's opinion, State v. Gloff, which found that at the trial language in the statute has a prospective force and applies when it says it applies at the trial of persons accused of using force against another, which is what we have here. And based on the plain language of the statute, it should apply to Mr. Pitts's case.
And that doesn't require, if we would follow that 12th district case, that doesn't require us to get into a retroactivity analysis, right? I mean, then they basically find this wasn't even a retroactive law.
Yes, that's my understanding of the case. And I think that that's actually a really interesting way to decide this, because at the end of the day, it's our position that this is a procedural rule. So that doesn't implicate the retroactivity concerns in any way. So by applying it prospectively to trials, you're not running into the retroactivity concerns at all. You don't really need to get into that analysis because it's purely a procedural change.
Well, so would the analysis change if it had gone the opposite direction? If the burden had initially been on the state and then it was changed to the defendant? Assume the statute says exactly the same thing other than, shifting that. Like, would that apply in your client's scenario where the action occurred beforehand, but the trial began afterwards?
I believe that the case law is clear when we're talking about to directly answer your question. I think the analysis would still be the same, that if the burden had shifted back to the defendant, that Mr. Pitts then would be on the hook if the statute took place after the effective date. And the reason why I say that is because in the 12th district case, at the end, near the end of its analysis, they cite two cases: an Ohio Supreme Court case called State v. Humphreys, and then a first district case, State v. Crawford, I believe. And in that Crawford case, the first district goes through this entire procedural history of the defendant. And at the end of the day, there was some back and forth between whether or not, so at the time of his trial, one particular burden was, I think it was his burden. Once his case came back on remand, the law had changed. He was entitled to a new trial. And at the time of his new trial, he was entitled to the new law. But at the end of the day, the trial court says the defendant is entitled to the law that's in effect at the time of their trial. So I think that carries the day. the defendant is entitled to the law that's in effect at the time of the trial, so long as that law doesn't impair already vested rights or impose new burdens or liability on the defendant. I don't think altering the burden of proof falls into that category, no matter which way you slice it.
You don't think if the burden of proof would be placed on the defendant, that would be putting a new burden on the defendant?
Well, because I think evidentiary changes that change the quantum of proof can be procedural in nature, then I think the answer is yes. I'm not saying that like across, I mean, there's exceptions to everything. But generally speaking, you know, the law says when the quantum of proof changes, that's a procedural situation, and we can apply that retroactively without running afoul of the rules of retroactivity. I mean, I think in this case, what it comes down to is the plain language of the statute says the statute applies at the trial of persons accused of using force against another. 12th district says at the trial means we apply it as at the trial. And that's all we're asking this court to do is reverse and remand and have the trial court apply the statute that was in effect at the time of Mr. Pitts' trial. If this court wants,
and it would not be applying it retroactively, though, according to your argument. I mean, there's a lot of cases out there that were cited by the prosecution where courts have found that this law does not apply retroactively. But in those cases, it seems to me the trial was concluded already.
that's correct.
So if this would only apply under your argument if you haven't had your trial, if the offense occurred before the law changed, but your trial happens after.
Yes.
If your trial happens before the law changed, it wouldn't apply.
Correct.
Yeah. Okay.
Yep. So yeah, and because the law changed in 2019, at this point, we're probably talking about a very narrow amount of cases that this holding would apply to. I mean, granted, it would be probably persuasive in future contexts, but in reality, this wouldn't apply to a whole host of situations just because of the recent change. But yes, just to summarize, we think that it's a pretty straightforward issue. At the trial means at the trial, this law should have been applied because it was in effect at the time of Mr. Pitts' trial. And just to touch briefly on the second assignment of error regarding the manifest weight of the evidence.
Ask you real quick. I'm sorry. I had another question on that. So if we would agree with you on this, are you saying that there's just an automatic remand in this case for a new trial, or is there a harmless error analysis that we have to do? I mean, is this just an automatic remand if we would agree with
I believe so. The state hasn't argued that this was harmless error, and I don't think that the state could argue that it was because this is a jury trial. So it's not a matter of remanding. This was a jury trial. They should have been tasked with deciding if the case had disproven the affirmative defense beyond a reasonable doubt. That is a substantial difference, and it's not harmless error because of the magnitude of that shift in burden. So no.
Well, presumably, I mean, getting to Judge Krause's question, I mean, presumably you would have to establish that you had tendered sufficient evidence from which a reasonable juror could find self-defense, right?
The statute says tends to demonstrate that the defendant acted in self-defense.
Okay.
So that's not a very high bar. Mr. Pitts in this case asserted that he was defending his little brother. So I think that would be enough to shift the burden then. Once the defendant puts on its case in chief, then the state would have to decide whether or not it could submit on its own cross-examination of the information that they presented in their case in chief, or need to call rebuttal witnesses. So for those reasons, I mean, this is a substantially different case now if the new law applies. And Mr. Pitts should be entitled to the new law applied at the time of the trial. I believe that regarding the second assignment of error, I mean, I think that this case gets reversed on the first assignment of error and we don't need to read the second if the court agrees. I just briefly want to touch on the elements. I think that all of the elements in this case regarding the use of force in defense of another have been met. Mr. Pitts was not at fault at creating this situation. This situation started the moment Mr. Turner picked up a child off of the street and drove away with him. Now, I respect the state's characterization that this was just a good Samaritan trying to do a good deed, but the affirmative defense doesn't consider the intentions of the prosecuting witness. It's all about the subjective belief of the defendant who's acting, in this case, under the impression that their child was just picked up by a stranger, and that stranger is now not willing to turn that child over to the older brother. Reasonable force was necessary in this case to effectuate the removal of the child from the truck, and the use of force was not likely to cause death or great bodily harm. A single punch does not meet that standard, and we can't view the harm that actually result as a justification for whether great bodily harm was there. It's just the act we have to analyze. Does a single punch meet that standard? And I think the answer is no. So for these reasons, either the first assignment of error, which I think decides this case, but on either assignment of error, we'd ask this court to reverse and remand for a new trial.
All right, thank you. Any questions of Ms. Nelson? Thank you. Mr. Crowley?
Thank you. Good morning, and may it please the court. Good morning, Ms. Nelson. Scott Crowley on behalf of the city of Cincinnati. And we're asking you to affirm because the retroactive application of this statute, it would violate ORC 1.48. It would violate Section 28, Article 2 of the Ohio Constitution. And it would not be compatible with Ohio Supreme Court case law. I think
let me stop you there and ask you about the 12th District's conclusion. And that is because the statute says at trial, there is no retroactive application because at the time of the trial, which is the only time it comes into play, it wasn't being applied retroactively.
Yeah, so I want to address that question, and I hope I did this correctly. The city did want to supplement the authority for this case. And so with regards to the 12th District analysis, their holding was that this applies prospectively to trials. And with regards to the State v. Brooks, and that's from the 5th District, they analyzed the 12th District opinion, and they reached the conclusion that that language is not necessarily a directive as to the applicability of the statute. It's more a reference to the time and place for the evidence to be presented, which makes sense because it would be at the trial. If there is evidence presented that would tend to support that the defendant was acting in self-defense.
Well, let me ask you this. What if the General Assembly just passed a statute that said at every trial, there is going to be 10 jurors or whatever your number. I mean, there would be no dispute as to retroact that because just whenever you came up to trial, you would say, I've got a right to 10 jurors, right? I mean, that would not necessitate a retroactivity analysis to say, well, my cause of action accrued 2 years ago, and therefore I don't have that right to 10 jurors. It's in the statute.
Well, I believe so. We're going over conduct, what is past conduct? And so in this situation, we're talking about past conduct that occurred in September with the defendant in this matter and how.
Well, we're really talking about burden of proof, and the burden of proof only comes up at trial.
Right. And so with regards to the burden of proof here, in terms of the self-defense analysis, it then goes to the state to prove beyond a reasonable doubt whether self-defense was here. And so to think of it this way, I mean, when we're talking about a change to the law, I mean, it's pretty clear from ORC 1.48 that a law cannot apply retroactively unless it's expressly said to. And as a prosecutor, when we're seeing a change of the law like this, with regards to the burden of proof, I mean, it's very explicit. ORC 1.48, the General Assembly cannot pass a law without expressly saying that it applies retroactively.
But the policy reason for that is so that people can adjust their conduct to conform to the law. In other words, you can't make, let's take a new drug. You can't make a new drug illegal and then retroactively apply it to somebody who was using it when it was legal to use it. That we don't have any of that here. We have, as Judge Bergeron suggested, it's something that happens at trial procedurally. The state wouldn't have altered its conduct in any way. The defendant wouldn't have altered his conduct in any way. So do we even have any of those issues? And don't we just then look to the statute which says at trial, and therefore it's not even a retroactive application?
I don't know if I necessarily agree with that, because with regards to State versus Brooks decision, I mean, it does reference, this, when the evidence is presented. And so I think State v. Brooks is instructive on this point, because I understand the court's position where we're talking about at the trial. But I think another element of ORC.148 and the Ohio Constitution is also just this express information to prosecutors like, hey, this is going to take effect now. And when we also look at State versus Jones, that's an Ohio Supreme Court decision where there was somewhat of this burden shifting occurring. And the Ohio Supreme Court ruled, no, this violates the state of Ohio Constitution. And so I do think there is that element in place where, yes, I agree with you. There is, we're talking about conduct to a certain degree, but also we are also talking about, there's a reason why we have ORC 1.48, and that's to kind of remove that disdain of retroactive application of laws. Because when we're talking about conduct as well, I mean, the victims didn't do anything different either. And so when we're talking about a shift in the burden to the victims and also to defendants that just had their trial prior to March 28th, where they very well could have committed an assault on the same day as Mr. Pitts, I mean, that's where we're talking about why we have ORC.1.48 and that section in the Ohio Constitution, is to kind of have that kind of solid foundation and that, predictability within the law. I think that's.
So you don't agree that this is just a procedural change? I mean, because it's not changing the elements. It's not creating any kind of new affirmative defense or taking anything away. It's not doing anything to punishment. So why is this not a procedural change?
This is a substantive change. And when we read State versus Jones, and I understand that Ms. Nelson did point out in her brief in State versus Jones that was overruled. We have to remember that there was really only one aspect in State versus Jones that was overruled, and that was the ex post facto analysis under the US Constitution. The Ohio Constitution from State versus Jones was not overruled. And in State versus Jones, they ruled that the Ohio Constitution, it was violated in Jones when we did that burden shift in back, I think it was in 1980 or 80 something when State versus Jones did come out.
Was the burden shifted to the defense or the prosecution in that case? I can't remember.
Okay, that's a very good question. Yes, Judge Krause, and I would like to address that. So the trajectory of the self-defense law went from common law, where defendant did have to prove by a preponderance of the evidence his affirmative defense, to Humphreys, where it was just defendant presented evidence and then the state had to prove beyond a reasonable doubt. And then after Humphreys, we go to Jones, where it went back to where defendant had to prove by preponderance of the evidence. So in Jones, there was this quantum of proof change that made conviction easier. Or no, wait, it made it more difficult in Jones. But here's the interesting point. That was all under the ex post facto analysis under the United States Constitution, which was then overruled by Collins and Webb, where we do not engage in this quantum of proof analysis to determine whether or not the conviction is easier or more difficult. And so when we look at State versus Webb, that analysis was rejected. And again, that was an evidentiary issue as well. That dealt with the definition of circumstantial evidence. And in that case, It was a judicial rule where ORC 1.48 did not apply and the Ohio Constitution requirements did not apply. So we do have to somewhat reconcile how we move here, because Jones said this violates the Ohio Constitution because of a quantum approved change and the Ohio Constitution. But then the ex post facto analysis was overruled in Webb. And then in Webb, they said the Ohio Constitution still applies. And it was a circumstantial evidence definition. And that's where we kind of get into this, again, this kind of predictability in the law. And that's why we need that express statement from the legislator to explain this will apply retroactively. So I understand Judge Bergeron's point where we're talking about, hey, this is just trial. But at the same time, when you look at the trajectory of the case law from Humphreys to Jones to Howell versus Porter, you know, it's just not that analysis. The circumstantial definition in Webb, you know, had to deal with trial as well. And they said that the Ohio Constitution does still apply. Jones is still good law. And that brings us to the retroactive analysis, where you have to tell us in plain terms and express language that this statute is going to apply retroactively to past conduct with regards to assault. And in this statute, that express language is not there. The Ohio Judicial Conference even referenced this in their publication, where the trial court needs to make a determination on whether or not this applies retroactively because it's not clear. Well, in Howells versus Porter, if it's ambiguous, if it's not clear, it is not retroactive, it is prospective only. And we're talking about past conduct. And so when we talk about past conduct, to have this effective date, where if your trial occurs before, I mean, it's just, that's why we have ORC 1.48 to prevent this type of unfairness, where if you have your trial before, you're subjected to a different standard, even though you committed an assault the same day than someone that had their trial the day after March 28th.
Well, but
So-
I
so
don't know
is
if
your-
that's really unfairness, because I mean, if we agreed with you and there's a line in the sand on that particular date, someone who does an act of self-defense the day before versus someone who does the same thing the day later gets a totally different standard. So I mean, the legislature has to draw a line somewhere, and I don't know that it necessarily means there's unfairness there.
And I agree with you on that, Judge Bergeron, but again, under ORC 1.48 in Ohio Constitution and State versus Jones and State versus Webb, they have to tell us. So then we also don't have not only inconsistency with regards to a date, but inconsistency with regards to jurisdictions, because now we have the 12th district and the 5th district, and then the trial courts as well, making determinations on retroactivity. So it makes sense, not just from, I understand your point with regards to trial, but predictability is important. That's why we have ORC 1.48 and the Ohio Constitution. So we don't have en masse trial courts making their own determinations here. You have to tell us if this applies retroactively explicitly, or we're going to have these issues within the jurisdictions of the state of Ohio.
Has the Supreme Court accepted any of these cases?
I am not aware of, I've seen briefs arguing that this was a matter of important public interest. I don't know if any of those have been accepted.
And no certified conflict?
I haven't seen anything with regards to, at least at this point, I am not aware, Your Honor. And so now the 12th district and the 5th district are in direct conflict right now. And so I think this court,
well, do you think we should certify a conflict regardless of which way we go?
I think that would be yes, for the following reasons. Again, it goes to that predictability that we need in the law for the trial courts. I mean, I agree with Ms. Nelson, this may be rare, but it still might come up occasionally with regards to whether or not this does apply retroactively.
No, I mean, I suspect there's a number of appeals in the pipeline across the state where this issue is at play.
I would agree with that suspicion as well, Judge Bergeron, I would. And so I just from, the trial court prosecutor in the trenches, I did State versus Pitts. I think certifying a conflict would help with the predictability, because I also remember reading, I think up in Cleveland, a judge ruled that it would be retroactive and it caused a murder conviction to just be thrown out. I think the state didn't even proceed on that. So to have some predictability here with regards to the law for trial courts would be beneficial. So I think it would be within the interest to certify for the Ohio Supreme Court. But again, I don't know how much time I have left, but so I understand.
About a minute.
I want to summarize then on the key issues that we discussed here then. So to Judge Bergeron's point, and actually everyone's point, Judge Krause and Judge Myers, with regards to that trial aspect and the procedure, I do agree with you to a certain extent that the purpose of retroactive laws do have an aspect with that in mind, but there's also that predictability and why ORC 1.48 in the Ohio Constitution is there. It's again to remove that disdain that Cook and Bracton talked about with regards to retroactive laws. So we have that predictability. And so it does not have that express language in there, and that's the key. So I would ask this court to follow the 5th District Court of Appeals, where we do have a law here that affects past conduct, and we have to follow then the retroactive analysis in Hiles v. Porter to determine whether or not that law applies retroactively. There is no express language here. And so in addition, this is substantive. State versus Jones said it. And State versus Webb only overruled the ex post facto US constitutional law analysis there. And so to conclude, ORC 1.48 does apply, Ohio Constitution does apply, and retroactive application of this law, it just does not also fit Ohio Supreme Court case law, specifically Hiles versus Porter as well. Thank you.
And you are at your time. Thank you. Ms. Nelson, you have 3 minutes.
Thank you. It's my understanding that there was a motion to certify a conflict filed in the 5th District. I checked that on Monday, and I'm sorry, I'm not sure if that's been actually ruled upon yet, but it's in the pipeline. So there is some conversation about conflict here. I think the memorandum in support of jurisdiction would be due early October. So there's some time to decide whether or not the 5th and 12th District cases are going to go up.
And if they do, are you suggesting that we wait for a decision for the Supreme Court, or that we decide and perhaps they would take ours in as well?
I think how do I answer that? I think both. I guess both. I imagine that because this issue is in conflict, this court's going to go with one side or the other. The issue is going to be. I'm not really sure how to answer that question from a judicial perspective. I respectfully, I mean, that's. I don't mean to threaten that I'm going to file an MISJ on this issue. But like that's kind of how this thing goes, and I anticipate that the state would probably do the same because it is an interesting question of law that's already kind of being discussed. So I just put that out there because the question was asked, and I did find that their motion was filed.
Thank you.
I think with respect to predictability, that once the effective date establishes that predictability, once the law goes into effect, as long as it's procedural in nature, which is what we are advocating for in this case, then it's clear that the law applies after the effective date. It doesn't control the conduct having occurred prior to the effective date. So the new procedure should be applied after the effective date. And with respect to the 5th District's decision, respectfully, out of respect to the 5th District, I think their opinion is quite unfulfilling. They don't really speak to the ultimate issue. Of course, the affirmative defense is going to be asserted at trial. So I think that's a disingenuous read of this statute to say, well, that language doesn't really matter in terms of its prospective force to trials occurring after the effective date. That's clearly what this statute, it says what it says. At the trial of persons accused of using force in self-defense, the burden shifting scheme applies. I think what the Fifth District really was doing is relying on all the previous cases that said this law was not retroactive. But as Judge Krause pointed out earlier, all of those cases concerned trials that occurred before the effective date. So once we're past the effective date, it's pretty clear that that's when the statute is intended to apply. Lastly, with respect to the Webb-Jones distinction, my understanding of Jones was that it made it easier to establish a conviction. There was less testimony necessary to support a conviction, and that is why it would violate the ex post facto rules, because I think one of the 4 components of the violation of ex post facto is an evidentiary change that makes it more difficult, makes it easier for the state to secure a conviction. But
It was in that case, it was detrimental to the defendant, the law change.
Correct.
And so they found it to be a ex post facto violation.
Correct.
Okay.
I believe that's the understanding. So my biggest takeaway in that case is like, I guess this goes back to the earlier question of whether or not the burden shifting back to, the defendant if we shift back to the defendant having to prove by preponderance of the evidence, whether or not that would create the problem in Jones. I guess I'm not really sure on the issue. My gut says no, because the burden changing the quantum of proof is procedural in nature. So I don't think it would really violate the rule against retroactivity, but Jones is distinguishable because it went to the proof necessary for a conviction. Affirmative defense is a little bit different than that.
Ms. Jones, Ms. Nelson, you are at your time.
Thank you. Just to conclude, we'd ask this court to reverse the remand for new trial. Thank you.
All right. Thank you both very much for your arguments this morning. We will take the case under advisement and give you a timely written opinion. And this will conclude the arguments this morning at the First District Court of Appeals.